The first official notice that you're going to get telling you to come to court will be for your arraignment. An arraignment is an old-fashioned proceeding. It used to be very important. It's not so important anymore. The purpose of an arraignment is for the judge to explain to you exactly what it is you're accused of having done. The reason we have arraignment is because there are plenty of places around the world where people can be arrested, even kept in jail, and never told what it is that they're accused of having done. In America, we don't believe in that, so we have an arraignment. When you come to court for your arraignment, you'll sit in the audience, you'll wait till your name is called. When your name is called, you come up here to the podium, and the judge will call your name and tell you what you're accused of. The judge will actually read the indictment or the charging document to you, telling you the exact date that you're accused of having done something wrong and exactly what it is. Then the judge will ask how you plead. You can plead one of three ways: guilty, not guilty, or no contest. Pleading guilty admits that you committed the acts that constitute the crime charged. Pleading not guilty means you either deny committing the acts, or you admit committing the acts, but you say that that does not constitute the crime charged. Or you can even admit that you committed the facts that would support that charge, except that you have a complete defense or justification. The classic example of that is if you intentionally shoot someone and kill them, but you do that under circumstances where it was necessary to protect your own life, then you can admit that you committed the killing, but you plead not guilty because you're entitled to defend yourself. Finally, a person could enter a plea of no contest. No contest says, I'm not admitting or denying anything, but I'm choosing not to contest or challenge the charge or charges brought against me. That should sound to you, it should feel to you pretty much the same as guilty, because it is. If you enter a plea of either guilty or no contest, then your case will then be set for a sentencing hearing, either immediately or at some later date, and at the sentencing hearing, the judge will decide how much punishment to heap on you. If instead you enter a plea of not guilty, then the judge will schedule your case for one of a variety of pretrial hearings or docket calls. It just took me longer to tell you what happens at arraignment than your arraignment will actually take. In fact, if you have a lawyer, you don't have to come to court for your arraignment at all. Florida law allows a lawyer to waive arraignment in a criminal case by submitting a not guilty plea in writing in advance. If you and I are working together, that's how we will handle it. You'll be excused from court at arraignment. We'll even take the time to notify your bail bondsman for you so your bondsman doesn't worry about your missing court. That's arraignment in Florida.